So yes, in those situations, when there is a gap in the law, in the sense that a new novel fact situation has arisen, has been brought before the judges, and the existing laws do not answer that. Okay, in those situations, what are the judges to do? And H.L. Hart says that in those situations, judges legislate. Okay, he is very frank about it. Okay, he says that in those situations, judges take into consideration, policies. Okay, as well as moral principles in deciding the outcome of the case. Okay, this is essentially what our philosopher Ronald Dworkin has disagreements with. He says that even in those situations, okay, there is apparently a gap in the law, also known as the hard cases, as we discussed. Okay, in those situations, judges uh, decide. Judges do not create the law based on policies or moral, or their own subjective moral considerations. Okay, it definitely is not based on policies, because policies are utilitarian in the nature. And who are to make policies? Your elected representatives, the legislators. They will deal with that. Okay, not judges. Judges are not elected representatives. Even when the judges are elected in many legal systems, those elections are of different kind. They do not truly represent the people. So, in those situations, then judges are to decide, adjudicate based on principles. Okay, though they are to decide matters based on principles. So, you have discussed the very important case of Riggs versus Palmer. Okay, but what was the relevance of that case? The relevance of that case was essentially this. Okay, in that case, it was not a gap. Okay, there was it was not a gap case, because there was no gap in law, because Palmer, okay, Elmer Palmer, who killed his own grandfather, who had bequeathed property to him in a will. Okay, and then there was talk of changing the will so as to remove him from what he would get under it. So to ensure that that does not happen, he killed his grandfather to inherit the property, to enjoy the property sooner than later. So in that situation, when the matter, in the light of that fact, when the matter comes before the court had to decide whether, okay, so he is convicted. Okay, he is convicted of that crime, so he goes to jail. But does he inherit the property? Okay, under the will, that was the moot question. So if he inherits, then it seems to be problematic, okay, in this situation. Okay, but the law relating to will, so for example, testamentary succession, okay, clearly says that, okay, if a will is created, then after the person who creates the will dies, the person in whose favor it has been created will get the property. As simple as that. The rule says so. But the court came to a different conclusion based on something called, a person will not benefit from his own wrong. So you cannot benefit from your own wrong. This statement that I just gave you is not a rule. Okay, it's what our philosopher calls as principle. Okay, so that's why I put that question before you guys the other day, that what is the difference between a rule and a principle. Okay, so our philosopher here says rules work in all or nothing fashion. Okay, but principles don't. Principles are certain standards, okay, that exist in a particular political community and is part of the legal system as well. Okay, part of the legal discourse as well. So when I say that rules work in all or nothing fashion, what do I mean? I simply mean that if there's a rule and a fact situation has been brought before the court, the rule either determines the case or it does not determine the case. Okay, as simple as that. Okay, so and if you have two contradictory rule, okay, one says that you shall do it and the other one says that you shall not, then in such case, what are we to do? We said that then we have certain other principles. Okay, lex posteriori derogate lex priori. So you always have some principle in that situation. But what we notice here is that rules either apply or they do not apply. If fact situation arises, rules either have an answer to it or they don't. Okay. So yes, in this fact that I just described, as was also described in the other class, it was quite clear that the rules did apply to the case. Okay, yes, it says if a will is made after the person dies, then obviously the property will be inherited in whose favor the will has been created. Okay, but then how did the judges come to a different conclusion? They came to a different conclusion based on this principle that one shall not benefit from his own wrong. So he murdered his grandfather, and from that he stood to gain from the will. Okay, so it seems that rule here comes in conflict with a principle. Okay, but that's not the case, because rules and principles are again incommensurable. What do I mean by that? That you do not pit a rule as against the principle. Okay, rules come in conflict with rules. Okay, but then we have competing principles here. Okay, one is that one shall not profit from his own wrong. The other one says that laws, if made by the parliament or the congress in a certain way, ought to be applied. Now principles, when they come in conflict with one another or each other, they do not function in all or nothing fashion. Okay, you can weigh between them. Okay, you can prefer one over the other. Okay, you can basically apply your reasoning process in this situation. So the thing is this, in this particular, as to which principle should give way to which. Okay, so it was found that the principle that one shall not profit from his own wrong prevailed over that of the principle that says that if rules are made by the Congress, ought to be applied by the judges. So that's essentially the distinction which was created, which our philosopher Ronald Dworkin refers to. Okay, that's how he distinguishes between principles and rules. Okay, so he defines that in the famous book by the name Taking Rights Seriously, where he calls, I call a principle a standard that is to be observed not because it will advance or secure an economic, political, or social situation deemed desirable, but because it is a requirement of justice and fairness or some other dimension of morality. Okay, so yes, that's what principle is. Okay, but his idea of morality again is not the kind of morality that many other natural law thinkers were talking about. So it's a little difficult for us to club him with those other philosophers. But then we say that he is a person who's saying that there is some kind of connection between law and morality, which is a position quite different from what H.L.A. Hart had. The rest of the discussion, I suppose, was already clear. I repeated this because it is relevant in today's discussion's context. Okay, so what is the discussion that we have for today? It is about separation of law and morality, and this has been a very important discussion debate that happened after the World War, essentially between H.L.A. Hart and then Lon Fuller, and also before Fuller, Gustav Redrock, a German philosopher. So what H.L.A. Hart's position is with respect to the relation between law and morality. It's discussed in the previous lectures. He essentially says that there is no necessary connection between law and morality. What does he mean when he says so? He means that the validity of law does not depend on its moral content. Okay, it is not that a law has to be moral in a certain way for it to be considered as law at the conceptual level. Then where else do we derive validity of law from? Can anyone answer based on the lectures that I have uploaded? Can anyone answer what validity of law according to H.L.A. Hart is?
Sir, logical reasoning.
No, please answer what you've been taught. Don't just tell me what you think. It's not logical reasoning. Yes, what is the criteria for determining validity of a law according to H.L.A. Hart? Students, Don't sleep.
So by recognizing it through the law of recognition by the officials.
Excellent, excellent. So there is a rule of recognition. Okay, it's not law of recognition, but rule of recognition. But you are very correct in pointing it out. Okay. You remember in H.L.A. Hart's philosophy, there are two kinds of rules. There are primary rules that lay down rights and duties, and then there are secondary rules, okay, relating to power conferring rules, okay. And then you have rules of amendment, change, adjudication, and then you have ultimately at the over that of all other rules, you have rules of recognition. Okay, rule of recognition determines what constitutes a valid rule. Okay, so we discussed what rule of recognition is. Okay, it has internal and external aspect. Okay, rule of recognition is essentially relevant for officials. They accept it from an internal point of view, but as an outsider, you will observe, okay, the empirical reality of whether it has been accepted or not. Okay, but then rule of recognition determines the validity, okay, nothing else. Okay, so if rule of recognition in a particular legal system is that if the parliament makes law based on certain procedure as has been laid down, okay, then it is a valid rule. Okay, if the law has been enacted likewise. Okay, so this is the kind of formal, okay, definition of law which has been given by H.L.A. Hart. Okay, so whether a law is valid or not will depend on whether it is in accordance with the rule of recognition or not, whether it has been recognized under the rule of recognition or not. Okay, that's it. Okay, so that's the idea of law. That's the idea of validity of law according to H.L.A. Hart. So whether the law is valid or not, it does not depend on whether the content of the law is moral or not. But then he says that when we say that there is no necessary connection between law and morality, we merely mean that and nothing more. Okay, what does that mean now? It is quite often the case that there are certain higher documents, okay, that lay down certain substantive moral requirements that laws which are enacted by the Congress or the Parliament has to also fulfill certain higher moral requirements as may be laid down under, for example, a constitution which provides entrenched rights. Okay, in such situation we see that within the legal system there seems to be a case of relationship between law and morality. Now this is something that H.L.A. Hart never denies. Okay, says that, well, if that is the case, that's the law, because rule of recognition says that these laws should have this specific moral content. But at the level of conception, the concept, okay, at the conceptual level, we do not define the legality of law, the lawness of a law, based on its moral content. This is something that I have tried to explain earlier as well. If at all you find any relation between law and morality in a particular legal system, it's because probably the rule of recognition recognizes it. Another way that there could be some connection is because the judges who are authorized to adjudicate, might take certain moral considerations. Okay, as he says, okay, in the case of penumbra cases, okay, Martin might take certain moral principles into consideration and decide a particular matter. Okay, well, again we see there is a connection between law and morality which is not denied by H.L.A. Hart. Well, yes, he says that. Well, all we said is that there is no necessary connection. Okay, but that does not mean that judges cannot take moral considerations in deciding a particular case. So in such situation, the law becomes law not because a particular moral parameter has been considered, not because of that, but because of the fact that the judges have decided the matter like that. Okay, now this is what the position is. Okay, she says that there is no necessary connection between law and morality. Okay, the connection is only contingent. Okay, so that's his position. Okay, now the implication of this is that you might come across a legal system where the laws are extremely outrageous, immoral. Okay, but maybe the laws there have been recognized under the rule of recognition. If that's the case, no matter how harsh, how immoral, okay, how outrageous, morally unacceptable, okay, deplorable those laws are, the laws are nonetheless laws. Okay, but then we have other philosophers, okay, like Gustav Redrock, okay, Lon Fuller, or for that matter, even Ronald Dworkin, as you have seen in the case of Riggs versus Palmer, okay, who would say that laws have to have, sometimes, okay, especially in the case of Redrock and Fuller, they say that laws have to have some moral content, okay. So Redrock's position essentially was that a law which is like extremely immoral, okay, crosses the limit of tolerable immorality, okay. If it has crossed that limit, it is not worthy of being called a law at all, okay. As opposed to that, our philosopher H.L. Hart would say that no, the law may be extremely immoral. It may cross that threshold of tolerability of immorality. Okay, maybe it's extremely outrageous, but we do not do any good by denying it the quality of being called a law. So we do not. So even when the law is extremely outrageously immoral, the law is still valid. Okay. It's still valid, okay? When is it valid? If it is recognized under the rule of recognition, okay? If that's the case, the law is a valid law. Now then he says that, okay, if a law is valid, do I have an obligation to follow the law? Well, if it is valid, then you have a legal obligation to obey the law. But do I have a moral obligation to obey the law? He says that you may not have a moral obligation to obey the law. Now, whether you have a moral obligation to obey the law will be subject to your choice, isn't it? Your moral judgment will tell you, okay? But from within the law, you have a legal obligation to follow the law because the law is valid, okay? That's what he says. That's what his position is. So this is essentially the debate between those who talk about separability of law and morality and those who talk about, inseparability of law and morality. So for H.L. Hart, he says that denying a law its quality of being called a law will not do any good to us, okay. Now you remember why he does so, okay. It's for the sake of clarity. Say that, okay, if everyone would take the liberty of saying that, well, an unjust law is not law, in such case law lacks the clarity that it should have, okay. Why is that? Well, each one of us would come to different conclusions about whether it is moral law or not. And if it is not moral, whether it ought to be, whether it ought to be called a law or not, okay. So to avoid that, because that will create confusion, okay, from utilitarian calculation itself, he was also a utilitarian, we have discussed in our earlier classes. He says, based on that utilitarian calculation itself, he says that, well, for the sake of clarity, even if law seems to be immoral, okay, it's nonetheless to be called as law, okay. Whereas others do not think so. Others say that if a law is immoral, okay, to a certain extent, because for Redrock, he takes the threshold approach, saying that, okay, not every immorality will deny the law the quality of being a valid law, but if it exceeds certain tolerable limits in those cases, okay. What is that limit? We will discuss. So in such situation, we do not call it law. But it is also possible, based on utilitarian calculation itself, that a law which is outrageous, okay, in such case, there is no, probably it is utilitarian, based on utility itself, probably it makes more sense to say that, well, the law is not really law. But anyway, we'll come to that later on. But for now, let's focus on the debate here, okay? So he maintained, okay, if you have gone through the readings, that a law, however immoral, will be law if it is recognized as a law according to the established rules of recognition. So, for example, if the law is enacted by the parliament under the rule of recognition is a law. Yes? Is a law, then under the rule of recognition is a law, then it is to be considered as law. It is to be considered as valid law. But if it is not recognized, then obviously it is not a case of valid law. Okay, so that's essentially what the idea is for him. Okay, so he argued that it is not to deny that they are law, but to correct their effects by other laws passed where necessary with retrospective effect. So he says that if we deny it the quality of law, then there is no scope for us to fix it. Okay, and sometimes we can even correct the effects of such law by virtue of making retrospective laws. So for him, retrospective laws, which are in itself considered as a kind of evil, for him that is less of an evil than denying the law the quality of being called a law. So for him, clarity is more important a necessity, or I would say virtue, than retrospectivity. So for example, so problem of prospectivity of the law. So that's why, as I said, even his arguments for positivism is a kind of moral argument itself, as I perceive, not necessarily by others. Okay, that's essentially what this is. Okay, now this position inspired many philosophers to disagree, okay, with him and come to different conclusion. Okay, so especially what had happened during the Nazi in the Nazi Germany's. Okay, so during that period of time, certain very atrocious laws were made. Okay, laws that disenfranchised people's rights, laws which were made whimsically, okay, retrospectively as well, okay, without notice, okay. So there are lots of problems with those laws, okay. Laws that took away your rights, took away your properties, okay. Laws that denied your humanness, okay. Laws that denied justice, laws that did not consider fairness, okay. Such kind of laws were made, okay. Now the question that arises is whether those laws which were made during the Nazi Germany, okay, Nazi regime, okay, are to be called as laws or not. So as you will know by now, okay, our philosopher H.L. Hart would say that, well, why aren't they laws if they are valid laws under the rule of recognition? Whereas there are others, okay, Redrock, okay, whose position itself, underwent certain kind of change, okay, would say that, well, these are not laws, okay. So this is in fact a real problem. This is not just a theoretical, problem. So after the World War ended, okay, so many of these people, okay, were to be tried, okay, but they were to be tried for what? So you know that if you have read, okay, the readings, okay, you see that certain military tribunals were established in Nuremberg in Tokyo, okay, where these officials of Nazi Germany and Imperial Japan, okay, who were accused of war crimes, okay, as well as crimes against humanity. Now you know that these are codified under the international law, but back then that wasn't the case. That's why the difficulty. So the defense, okay, these people were accused of, war crimes, okay, crimes against humanity, okay, but their defense was that, well, we were acting under certain lawful orders. We are merely, subordinate officials. We have been ordered by our seniors to do this. So, for example, we were ordered by our seniors to execute people. We were ordered by our seniors to do experiments on humans. We were ordered by our seniors to put people in concentration camps, okay, labor camps, and kill them and then burn them. So that was their excuse. It was not us. We were ordered. We were merely following the law. Now, whether that's an acceptable defense or not, that we were merely following the orders of our. So hence, they said that their actions were within the law. Okay, they did not do anything which is unlawful. Okay. So the problem is that, well, they were following their orders, okay, and before these incidences happened, there were no such codified laws, okay, that prohibited such activities, okay. So how do you punish them? They are to be punished for what, okay? But it seems that they have done something wrong. So if they have done something wrong, that is wrong based on certain comprehensive moral principles, isn't it? It's wrong to commit such atrocious acts, okay? But that was not the positive law. at the domestic or even at the international levels, although many philosophers say that international laws are merely positive international morality. But forget about it. Let's consider that to be international law to be also a kind of positive law. If that is the case, then what do we do then with these people? Okay, so one of the options was that let's make retrospective laws. Okay, let's make laws now that retrospectively make whatever they did, okay, as punishable acts. Okay, but the argument was that any retrospective punishment of these acts, okay, as they argued, would contravene the basic rule of justice that a person should only be punished for crimes against the law, okay, that is nullum crimen nulla poena sine lege, or you can say the nullum crimen sine lege, okay. So this is what the problem is, okay, this is what the situation has been, okay. Now, whether under the laws, okay, in which, based on which these people functioned, okay, whether they were laws or not laws, okay, is a question. So as you see, H.L. Hard, okay, from his position, okay, having, seems that he thinks that all these laws were laws, okay. Now, why were these laws? According to him, these laws were accepted by the officials under the rules of recognition, and if the officials accepted it under the rules of recognition, then these are laws, okay. Why deny this the quality of being law? Because you think it's morally wrong, okay. So you know why he says so, we already discussed, okay. But then these laws suffered from many, deficiencies, okay. So the problem with, democracy is that the democracy is only as good as the people, there are in the in that system, okay. So the guarantee, okay, the bulwark, the protection as against authoritarianism or dictatorship, okay, depends on what kind of people there are, okay. How important is it for them that their voices are represented, okay, through democratic institutions, okay. Quite often it is possible that usually after as you see, when a country suffers, okay, for whatever reason, maybe because of some war in which they have lost territories or they have lost power or suffered humiliation, or maybe there's a economic crisis, okay. During those crisis situation, okay, when the existing institutions fail, okay, some charismatic leaders will come to power, making some bold promises that they hold all the answers to all kinds of woes that particular society face. And people who are already disenchanted, distasteful of the existing institutions, they get carried away and they fall for all this, okay. Now, however, that sensible people know that it is beyond the capacity of one individual or a few individuals to fix the woes, okay. It's the collective responsibility of everyone to fix the collective woes that we all face, okay. It's beyond the capacity of one charismatic leader, wheresoever it is on the political spectrum, be it on the left or be it on the right, okay. It's not possible. But then, in those distressing times, okay, when people do not have much, okay, just the way you see, then when you are, completely fallen, when you have no hope, you take the name of some almighty, okay, please help me. It's no different in such situation. You look up to someone who comes to you with big promises. Like, I'll do this for you, that for you. And while doing so, okay, they also blame certain communities, okay, as you have seen in the case of the Nazi Germany, okay, as is the case in almost in today's time, many places you see, okay, the same thing happening. They come to power by blaming certain groups, because you have to blame someone for the woes that we have now, okay. Then it's easier for you to distract people and then really not do much to fix the problems, okay. So yes, but if you have smarter, intelligent, educated, erudite, not bigoted, okay, progressive citizenry, they will not fall for this trickeries, okay, these casuistries, okay, that these leaders are extremely good at, because they're also good at oratory, okay, they're able to connect with the masses. So yes, that's the problem with democracy, that in democracy a charismatic leader exploiting certain problems that the society is undergoing, certain crisis, they come to power, and they are so charismatic that eventually they are able to overturn all other institutions, including even lawmaking institutions in which there are reasonable checks and balances. And then ultimately they say that, eventually it's a long process, ultimately they say that, well, what I say is the law, okay. So, and then you give up all semblances of what we call as rule of law in a legal system, okay. So the problem with democracy is that in democracy there is no protection, okay, against eventual autocracy or dictatorship, okay. Democracy is considered as the what should I say, the least worst form of government, okay. It is only as good as the people there are, okay. Now the same thing happened in Nazi Germany, okay. A charismatic leader comes to power, okay, to redeem the lost glory of fatherland, okay. But then in the process topples all democratic institutions, okay. People's civil liberties were suspended, okay. Emergencies were imposed, okay. And all those protections which were there, okay, were gone. Now you see, in Indian judiciary had, during its tussle with the executive, had done a good deed, okay, but many might disagree. It was laying down the basic structure doctrine, okay, that not even democratic majoritarian government can overturn. But it depends, because your judiciary also changed. They also cut out the government sometimes, okay. So anyway, the thing is that this is what had happened. People's civil liberties were suspended, emergency was imposed, okay. Now they could just change the constitution, okay. So entire German liberal democratic setup that they had was completely converted to something that was not recognizable, okay. So that Weimar Constitution was gone. It became a hideous abomination, okay, as has been said here, of tyranny. And so what were its features? Its features were that frequently retrospective laws, retrospective laws, okay, would be created that will punish the guiltless, or sometimes even excusing atrocities. So a police, okay, who would otherwise be bound by the law, if they have harmed people that you don't like, okay, their acts are justified, okay. And then people who are not blameworthy because they have violated any existing law, okay, were punished nonetheless. And then there were enforcement of secret, okay, unpublished laws, okay, laws were not published, okay, whatever almighty Hitler would say would be the law, okay. So people had no ways of knowing what laws expect of them, okay. There was complete discretion, no restraint, no checks and balances. These were just momentary wishes of the supreme leader. And even his verbal orders, okay, were considered, as to have enough authority, so that would justify exterminating an entire race, okay. And why are these important? Because Fuller's rule of law is based on this, okay. Then yes, frequent lawlessness, okay. Extrajudicial punishment, okay, by the state according to the party in the streets. So if you have seen the movie, what was it? Yeah, the second Batman movie. When Bane comes to power, and then how people are, tried in kangaroo courts and then punished. Okay, so things like that. And then unification of legislative, executive, and judicial power. Usually, the separation of power was completely destroyed. All united in the supreme leader, the Führer. Okay, and courts were intimidated. They could not decide anything against that of what Hitler's wishes and desires, okay. They had to do what the party officials say they should do. So yes, these were certain woes, these were certain deficiencies which were there, in the laws, okay, as were there in the Nazi Germany. Now, would this be enough problem for our philosopher H.L. Hart? Well, apparently not, because he was defending the legality of these laws. Okay, says that merely because these laws do not, Dark Knight Rises, yes. So yes, merely because these these laws do not have have moral content, does not mean that we deny these laws legality or validity of these laws. Why is that the case? Well, these laws were recognized by the officials. So under rule of recognition, these laws were recognized. So these are valid laws, okay? But whether you ought to obey them or not is a separate question. That's a moral question, question of moral obligation. So he says that these two are to be kept separate, okay? Now, as opposed to this position that H.L. Hart, held, another philosopher, a German philosopher, okay, who was kind of positivist before the war, held a completely different position subsequently. And his name is Gustav, Redrock, okay, a professor of law at University of Heidelberg. Whatever, all those details, you go through it. He came up with something called Redrock Doctrine, okay? And that's something which is very important and is in fact the positive law under the international law as of now. Okay, the basic idea essentially is this, according to him, that laws could laws could be immoral. Okay, not every other immoral laws will not be considered as law at all. Okay, but there is a threshold, okay, that of immorality, okay, that the law should not cross. If it is beyond that, okay, if it is such outrageously immoral, okay, in that situation, we don't call it a law at all, okay. But his view was different earlier, okay. Earlier, he held that the idea of law, okay, had three aspects, okay, that law serves expediency, okay. What does that mean? So yes, if you remember, we had discussed Saint Augustine's, position, and that of this fellow. What is his name? The first contractarian, Hobbes's position. Okay, they all held this idea that law serves some kind of expediency. Okay, some minimalistic purpose for which exists, and that is human coexistence. Okay, and not for some higher exalted purpose. Okay. Then he says that it also serves justice, okay? So apart from law's expediency, it also serves justice. And then thirdly, he says that it promotes legal certainty. So you see that his philosophy was predominantly legalistic or positivistic, okay? Although he talks about justice here, okay? Then he said that the legal certainty that positive law affords may justify even validity of unjust or inexpedient laws, okay? So yeah, he says that this is the importance, okay, that he says that certainty of law, okay, just like the other guy, H.L. Hart, okay, earlier he held this view that certainty of law is more important than anything else. So even if it seems to be unjust or inexpedient, it is nonetheless law, okay, because for the sake of clarity, for the sake of certainty, okay. So and then he said that, but argued that the demand of legal certainty has no absolute precedence over the demands of justice and expedience. Okay, so unlike the other hard positivist, he says that this supremacy of certainty, however, is not absolute. Okay, there are sometimes, okay, when we say that, well, no. So he says that conflicts between these qualities are left to resolution of individual conscience. Okay, conscience will usually choose legal certainty over personal conviction, but there may be shameful laws which conscience refuse to obey. So essentially, his position here, if I'm able to explain this correctly, he leaves this question of preferring either legal certainty or justice on the other hand, up to the subjective discretion of the individual judges. So if the judges think that, well, in this situation the law is so shameful that we need not obey this. So he leaves it up to the judges. So that was essentially his position. However, subsequently, after the World War had ended, he said that no, even this question should not be left to the subjective choice discretion of judges. But if the laws are so unjust in certain situation, okay, then the judges have a duty to not follow those laws. Okay, that was his position. Now we will discuss this in the next class. Okay, we have an important case with respect to this by the name. There are many grudge informers. Okay, so the next important context in which we are going to discuss this debate will be grudge informers case. So with that, we conclude our discussion for today.